Good afternoon and welcome to the Senate Judiciary Committee meeting of March 15th, 2022. We're going to open the day by starting the public hearing on House Bill 1086 FN and recognize the prime sponsor, Representative Abrami. Good afternoon, Representative.
Thank you, Madam Chair. Good seeing you. And for the record, first off, I did hand out this before you. It's about 11 pages. Well, probably 6 because I think it was double-sided that I'll refer to in a few minutes. State Rep. For the record, State Rep. Pat Abrami, Rockingham 19 Stratum. And Madam Chair, I'm here to introduce House Bill 1086 relative to concealment of course of action. This issue was brought to my attention by a constituent, Brent Arbogast, who is also here today to testify. So hopefully he can, if there's no other senators or no other House members or senators, I would suggest starting with him because he can set the stage. I'm an engineer, I'm not a lawyer, but this whole issue resonated with me, and that's why I filed the bill. So if a person has been wronged and the statute of limitations on filing a suit has passed, but you discover that a fraudulent concealment had occurred, the clock on the statute of limitations gets reset if this bill is passed. The period of time the concealment occurred shall not count in determining the time of limitation of commencing the action. This bill does not change the statute of limitations applicable to the particular cause of action, but changes when the clock starts ticking. Before filing the bill, I went to Legislative Research, who produced a list of states that have fraudulent concealment laws, and that is what's before you that I handed out. There are 14 states that have fraudulent concealment laws on the books, and New Hampshire actually has one of those, but only for cases of construction. And that could be seen on page 8 of what I handed out. Of the 14 states, only 6 have comprehensive fraudulent concealment laws: Massachusetts, Vermont, Connecticut, Missouri, Illinois, and Indiana. We modeled the bill based on the Massachusetts statute, which is on page 6. Our drafter here at the State House changed one thing. In Massachusetts, it says fraudulently conceals, but our drafter, for whatever I was going to argue with him, for whatever reason, changed it to purposely conceals. So other than that, the bill before you reflects what Massachusetts has. What I will say is that in the House, this bill was well received. It was overwhelmingly passed and was on the passed on consent calendar. And that includes the chair of the Judicial Committee in the House, who is an ex-lawyer, he's always a lawyer, an ex-judge. So with that, I hope you will consider this bill, and I'll take any questions, although I'm not the expert. The fellow behind me knows more about this than I do, but I will take any questions.
Okay, thank you very much, Representative. Are there any questions from the committee? Okay, seeing none, thank you, Representative.
Thank you, Madam Chair.
The chair will call Brent Arbogast. Good afternoon, Mr. Arbogast.
Good afternoon. Thank you for having me today. So basically, I'm here to testify in favor of the fraudulent concealment bill. I think trying to contribute to the community based what happened to me, and then is probably unique. Hopefully it's unique, but it was a real eye-opener, and the fact that I feel like I could not get justice in New Hampshire because we lack this type of law, but I could get it in Massachusetts and those other states. I think it'd do a lot of good. And basically, let me just go through what happened to me. I graduated college, got a degree in chemistry. I was All-American wrestler. I worked for landscaping companies, like 2 of them for 7 years. I'm a hard worker. There was fuzzy math at Collins and Aikman. I worked there for a year, running an analytical laboratory. And they went bankrupt. I got laid off. I got recruited to work for a position that they said was an exempt position, like the one I was working at. And I was very excited about that. And once I started work, didn't take long to realize it was not really an exempt position, and they were just turning the labor laws on their head by labeling someone exempt and making them work 20 hours of overtime a week for free, right next to somebody who just graduated high school a few years ago and was not $40,000 in debt and drove a brand-new Camaro. And so I said something internally, and I tried to just be professional about it, but they were very nasty. And they basically, over a period of a few months, had to get me out of there by accusing me of this, that, and the other thing. And right before I left, I filed a complaint with the Department of Labor and the Massachusetts Attorney General's office because they were violating the labor laws. They got the district director for the Wage and Hour Division called me, suggested I get an attorney because of the statute of limitations, and his office was, swamped with complaints. So I looked around for an attorney. I really didn't want to file a lawsuit. I just wanted to settle this. I wanted a good letter of recommendation and move on. I had only spent a year in my previous position. I was young. I had only spent a few months at this place, and I just wanted to get out of there without ruining my career. So then I finally got a list of attorneys. I noticed one of the names, an attorney that I met with. I looked for attorneys. He gave me a list of local labor attorneys. One was a brother of a childhood friend from Nashua, and I saw his name right away, and I called him up, and we decided to meet, and he declined to take my case because he was not licensed to practice law in Massachusetts. About that same time, I had filed a follow-up with the complaint because I couldn't find an attorney. The Department of Labor Wage and Hour Division was investigating, was pretty much at the end of their investigation of this company, and they had over 150 misclassified young employees that they were basically forcing to work overtime for free because they didn't really know how to manage the place, and it was not a good situation. It was very unhealthy. I didn't know this, and so around this time, this attorney that I called who couldn't represent me before says now he can represent me because his friend's going to sponsor him. Well, basically what was going on was he was actually working for the large pharmaceutical corporation to conceal everything, to make sure that I did not talk to the Department of Labor or the Massachusetts Attorney General's office, to give them the impression that I was being represented by an attorney when I wasn't, and just basically to save this company from a class action or what, I don't know. But when he decided he was going to represent me, it was to basically conceal everything that was going on, okay? He had me write a letter to the company asking for all my files, which he did, but I don't know when he got these files, but there's a stack of files about this big that basically shows them in this big scheme to try and get me out of there by making up all these documents and job descriptions and whatnot. At the time, they were involved in like a labor dispute, which I knew nothing about at the time. I don't know anything about unions or anti-union people, but apparently it's a big deal in big industry, and I think part of it was I got caught in the middle of that, because if you classify someone as exempt, it's much harder to join a union because you don't have a community of interest with non-exempt employees. So that was kind of part of their strategy. What happened was the time went by. They ended up adjudicating this. The company refused to comply. I didn't know any of this at the time. The district director resigned. About a month later, a new district director came. send me a letter that says, Mr. Arbogast, we know the Mass AG office told us that you complained about something, and could you send us more information about the complaint so we could take action? Well, that had the effect of me thinking nothing ever happened with it, when in reality, a lot had happened, and my attorney knew it at the time, too. And just like I did with all the other correspondence from law enforcement, I gave it to my attorney for him to handle. About 2 months later, I get a call to go down to his office. He shows me a complaint that was filed on my behalf a month prior, without ever talking to me. I had no clue. I did not give him permission to file a lawsuit on my behalf. We never talked about filing a lawsuit. I never saw any complaint. The lawsuit that was filed by an attorney I never met, never even heard of, by a very prestigious law firm. Which really, at the time, I trusted this guy from personal relationship. And at the same time, I was reading where they represented to the court that the law firm and the attorney was representing me. I was presented with a contingent fee agreement that they were going to represent me in this case. So basically, they tried to get me ratified what they had previously done. So I signed the contingent fee agreement. That day, the attorney, who I never met, filed a stipulation to enlarge the time with the company. And basically what they did that day was to tell the corporation that they can say anything they want about me in the pleading, and they're not going to get any pushback at all, because I basically was not represented. And that's what happened. They filed an answer that was of totally false and very bad accusations against a young professional just trying to start a career. And I'll tell you that when I got the job at this company, they made me sign a very large release, including my civil court records. And they certainly would not hire me if the files that were in that lawsuit that are totally false, and that I did not have an attorney. I had people pretending to be my attorney on the company side to try and cover this whole thing up. They would not hire me. And as a chemist, the equipment you work with is a lot of capital, and these are large institutions. So word gets around, I think. I didn't realize. I thought it was a bad economy because my career basically ended after this. But they got an offer of judgment that they concealed from me. They concealed the answer from me. The guy just stopped representing me. He called me up. He went to the scheduling. He made sure there's like a scheduling conference where you're supposed to exchange evidence before preliminary, so the judge can. He made sure that they broke the rules to make sure there was just oodles of evidence against them. He made sure that none of it got exchanged or was available for the judge. Then he called me up and said the judge really wants this case settled quickly because your case lacks merit, and the judge believes your case. I believe your case lacks merit and should settle quickly. I was like, what are you talking about? And he kind of got angry with me, and he's like, oh yeah, what does she know? She's just a federal judge. She's seen hundreds of cases like this, whatever. So then he basically quit after that, which I didn't know. He was my only licensed attorney that was licensed to practice law in Massachusetts. He was supposed to, by the contract we signed, represent me without a limitation on his scope. I don't even know what local attorney was, but anyway. I basically got bamboozled into signing a thing that said I lost, even though I got a modest sum for an overtime claim. I don't think an attorney would. If I was an attorney, I certainly would not. I would certainly sit down with a young person starting their career and say, "Do you really want to risk suing one of the largest multi-conglomerate corporations in the world for $5,000 at the beginning of your employment?" Because I certainly would not do that. So, and as a matter of fact, I would pay $5,000 right now to take those records off of the. There's a public access to corporate electronic records. So basically, I moved on. I had to give all the documents up. They were supposed to be destroyed. I had no clue anything wrong was going on. I had just had a son. After that, like I said, my career was basically ruined. I couldn't find a job. I moved about 4 times, got divorced, living in 1-bedroom apartment with my son, just trying to make sure he had a decent life. Finally, in 2018, had to move again. The guy would not renew the lease for me, but he wouldn't tell me why. And I looked and looked and looked for an apartment along the seacoast. It was very difficult. I had to sometimes had to pay money just to apply, and then just kept being told I did not meet their standards. Didn't meet their standards. Okay, finally, someone rented to me in Exeter, New Hampshire, and within the first week or two, I noticed I could see the old law firm office from my windows. And I forgot about the part where I had to destroy the files, and so did my attorneys. And my son was about 12. And about that time, I was starting to think, I took a stand on something. I think that probably has something to do with it. But also I was told that I acted like, my attorney said I acted like a belligerent jerk, and that they were just going to say that, and he told me they were actually going to sue me for bringing a frivolous lawsuit against them, and I would have to end up owing them money. So basically, I requested both attorneys if they had any records left, that I could use to show my son how kind of not to act in a situation at school or work, because it seemed like the way I acted was not the right way. And the attorney, who was supposed to be my lead attorney, said, I don't think our law firm keeps paper copies longer than 10 years. And I said, what about electric files of anything, any files? He's like, I'm not sure about electronic files. And I was like, I pushed him like, well, can you make sure about electronic files? And he told me, well, just so you know, I had hardly anything to do with your case. I had very little role. I was just acting as local counsel for the other attorney who wasn't licensed and never got admitted to be licensed, couldn't sign papers, couldn't file. And I was like, what are you talking about? You called me. You're the only one who appeared in front of the judge on my behalf. You called me, told me to settle a case because you thought the judge and you thought it lacked merit. The other guy wasn't licensed to practice there. And so anyway, the other guy called me up, both New Hampshire lawyers, said, I was the lead attorney. He was not. All the court documents say the other guy was the lead attorney. This guy didn't even make an appearance. He couldn't sign a paper. Anyway, the one attorney suggests I get a Pacer account to see the electronic files related to the case. So about a week later, the Pacer account came in the mail, and I see the answer. I see a forged document with my name on it that says we conferred when we never did. So I got my attorney's forging documents. It's not funny, but then about 2 weeks later, the friend attorney, I picked up the file in his office, law office, and I saw all these files he had concealed from me that said that the Department of Labor did an investigation, that decided I was misclassified, that I was owed money. I saw the offer of judgment where the company offered to take judgment against them and pay me the same amount that they gave me, but then it said in the court files that I was guilty or that I lost the case. I saw a lot of bad stuff that he concealed from me. So I filed a grievance with the New Hampshire Supreme Court Discipline Committee, who happens to have the same discovery rule that applies to, torts or lawsuits, for most lawsuits in New Hampshire, which is basically a statute of limitations is told until the victim either discovers or should have discovered through reasonable diligence that they, were a victim or that they were harmed, okay? So I submitted the grievance, and with all the evidence, with the contract that says there's no limited scope, they knew that the one attorney was not licensed to practice in Massachusetts. They knew the other attorney basically, never did, he didn't, there was no such thing as local counsel in the contract. There was a lot of things that were wrong. So they wrote back and told me, first of all, the statute of limitations had run because I should have known that I was a victim because these documents have been on Pacer the whole time. And I didn't even know what Pacer was. And even if I did know what Pacer was, I was on the hook for their fees to do the research and stuff. That was in the contract. So in other words, I was paying their Pacer fees due to the contract, their overhead, to do legal research and stuff. So you shouldn't assume that someone who hires a lawyer is going to get their own. You pay money to do legal research, and that's how I was supposed to know that these documents were on the Pacer database. When I got the Pacer database, within 2 months, I somehow accrued about $370 worth of fees just from clicking buttons. Okay, so the point is that they made up some kind of excuse of how I should have known that I was a victim of a really convoluted fraud of teamwork scoundrels that is really unbelievable. And he never denied the grievance. He didn't respond to the grievance. He didn't deny it.
Mr. Arbogast, could you tell us where you are today, what's happening today? Because you've already given us a lot of information,
Yeah.
so we
So-
need to wrap it up, please.
Okay, so where I am today is I'm here testifying that after I appealed the grievance, and basically they endorsed, there's a very reputable person, Superior Court judge, they endorsed their attorney's behavior. And so and you can take it or leave it, I don't care, I'm just doing my job. This will take the decision out of the hands of a judge or the subjectiveness, and it's good for them too. So if you can prove that someone fraudulently concealed something, you don't have to prove that you were reasonably diligent. If you can, and proving fraud is a high standard to meet. So if you can prove that somebody fraudulently concealed a cause of action, then you are not going to be subject to this arbitrary measurement of whether or not you were diligent. And basically, you got two choices. You can either get justice for people who are victims of crime, very bad things, or you can give the criminals peace of mind. That's your choice, because that's the other argument. And I want to say one more thing. I learned that the Attorney Trials Association is going to be here to testify against this law. I want to say that they had a conference call with Representative Abrami that he asked me to sit in on, and they basically fed him false information about the bill. And they said that it wasn't going to even do anything, it wasn't even going to matter, that it wasn't going to change anything. And I think it's quite ironic that the New Hampshire Association of Justice we're talking hundreds of kids that were exploited just out of college, tens of thousands of dollars in debt, going through a traumatic experience because of serious corruption. And to call a state rep, give them false information about a bill because you don't like it, I think is, especially when you're an organization. Finally, I would like to say that I think this is good because my last mention here is that it's very important to have a well-functioning judicial system and a court system. And if you look at what's going on in Ukraine, if you go type up Ukraine corrupt courts, you're going to get about 10,000 responses about how corrupt the courts in Ukraine are. And basically, if you don't have a peaceful way to solve issues, and if you think like what men did to me is going to be somehow just forgotten and society's going to go on, it's not going to, I don't think that's going to happen. So I just think that it's better to get justice than it is to give peace of mind to criminals. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
The chair will call Lindsay Nato. Good afternoon, Ms. Nato.
Good afternoon. For the record, Lindsay Nato from Orrin, Reno. I'm here on behalf of our clients, the American Property Casualty Insurance Association, as well as the New Hampshire Association of Domestic Insurance Companies. We are here in opposition to the bill, and I apologize for the lateness. We did submit a letter just now as well as an email earlier today as we've just reviewed the bill. We do have concerns with muddying the waters of how the current statute of limitations and tolling under the discovery rule works. The discovery rule is a pretty well-established rule that's been in place for quite some time. If the purpose of this bill is to permit a claim to be brought when the statute of limitations was missed due to some sort of fraudulent conduct, we believe that's already covered under the discovery rule, and therefore this bill really is unnecessary. The current discovery rule provides a balancing. So it includes the new or reasonably should have known standard. And we think that there's good reason for this because it requires some due diligence on behalf of a plaintiff while also protecting a plaintiff for things that they couldn't or shouldn't have known about. And again, we feel that the current existing system in place is working, and I am not familiar with the case that led to this legislation. It sounds awful, and I don't take a position on that, but I think generally how the statute of limitations and the tolling statute works is working fine. And I also just did want to note and correct the record briefly. I think before the House, which again, we didn't testify at, and I apologize for that, the House report provided that there was this same language in construction cases, and it is actually quite different in construction cases for your understanding. So in construction cases, there's a 8-year statute of repose, and I have to admit I had to go back and remember law school days about the difference between the statute of repose and the statute of limitations. But basically in construction cases, there is a strict 8-year statute of repose. So whether or not the plaintiff knew or should have known, you've got 8 years from the time of the construction. However, there is an exception to that exception, which is in cases of fraudulent concealment. And in those cases of fraudulent concealment in construction cases, the discovery rule comes back in play. So again, we're balancing trying to protect the construction industry in those cases with also having the discovery rule to help those plaintiffs when there has been some sort of fraudulent concealment. So again, we think the current system is working. It's very complicated, but the current law has been tested with time. It's been interpreted by courts. Plaintiffs and defendants, are used to arguing over the statute of limitations issues, and we think the current system should stay as is.
Okay, thank you very much for your testimony. Are there questions from the committee? Senator Khan.
Thank you, Madam Chair, and thank you, Ms. Nato. You mentioned the discovery rule and the 3 years. Is that covered in the same statute? No.
It is. So the current statute of limitations in 5084 is that the plaintiff knew or reasonably should have known. And so that phrasing is what's referred to as the discovery rule. Because it's either you discovered that you had a cause of action and that's when the clock starts ticking, or you reasonably should have known that the clock starts ticking. So you can't turn a blind eye to the statute of limitations either.
Right. If I can continue, and the construction statute is where?
That's in the same statute. It's just a later section of 508, and I want to say it could be 4B. I did hand in testimony from George Russo, which does cite to those sections of the law, but it is all in 508.
Do you have a follow-up, Senator?
I see that we have the letter. I just can't observe I see 5084. I don't see.
It is. It's 5084-B, as in boy.
Thanks. Got it.
Okay. Are there any further questions? Seeing none, thank you very much for your testimony. The chair will call Marissa Chase.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Marissa Chase. I represent the New Hampshire Association for Justice, a statewide professional association of trial attorneys. I just wanted to clear up some misconceptions. When this bill was first filed before a House hearing, I reached out to the prime sponsor, Representative Abrami, who kindly set up a meeting with his constituent. We talked through the bill. Our members kind of can't come to a consensus on the bill. We did not take a position in the House, and we are not taking a position in the Senate, because we truly can't figure out what exactly it does. We can think of some legal hypothetical scenarios, but frankly, our members have not seen where this issue has come into play in New Hampshire in the past. We don't think it necessarily does any harm. I called Representative Abrami yesterday just to let him know that there might be some concerns, and we were still trying to think it through. But I just want to be very clear, we are not taking a position on House Bill 1086.
Great, thank you very much for your testimony. Are there any questions? Seeing none, thank you very much.
Thank you.
Okay, are there any other members of the public who would like to speak to House Bill 1086? Okay, seeing none, we'll close the public hearing. Thank you. Yeah, no. Oh, that's okay.
You guys gonna sort that?
Okay, that's it. Okay. We're going to open the public hearing on House Bill 1388 and call the prime sponsor, Representative Nutting Wong.
Thank you for the opportunity to introduce HB 1388 relative to the unsolicited disclosure of an intimate image. This bill would criminalize the unsolicited disclosure of an intimate image, otherwise known as cyberflashing. This bill, if it were to become law, would make the unsolicited sending of genitalia via electronic device between adults a misdemeanor. The law currently protects minors from receiving images from... Sorry, The law currently protects minors from receiving graphic images. This bill would bridge the gap to protect adults from the same harassment. When I receive a message or email, I expect to have a conversation, not send graphic images with no warning. These images are often sent without prior contact purely to get a response, and when I've received one, the advice I'm given is to just block the sender. Indecent exposure is a similar crime, often with no proof, with similar recourse as I'm asking in this bill, but a cyberflasher can send many more images at a time with proof right there. For these reasons, I ask you to pass this bill and to bridge this gap in the law.
Okay, thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you. Okay, is Representative Abbas?
He's not here. We're doing criminal justice up at the House right now.
Okay, thank you. The chair will call Lynn Charlotte.
Good afternoon, Madam Chair and members of the committee. My name is Lynn Chalette. I'm the Executive Director at the New Hampshire Coalition Against Domestic and Sexual Violence. I'm here to speak in support of House Bill 1388 because it closes a loophole in our existing statutes, and it does that in a way that aligns with other laws that we already have on the books addressing sex crimes against minors. Although this bill was not a request of the coalition, we support it because it will help to ensure that non-consensual disclosure of intimate images is responded to appropriately in our state. So in my testimony, I'd like to do two things briefly. I'd like to talk about the very serious nature of this crime, and I'd also like to talk about how this bill aligns with the existing statutory framework. So first and most importantly, the unsolicited disclosure of an intimate image is a serious form of sexual violence. I think you all know sexual assault is a forced or manipulated or coerced sexual activity. It's a crime in which the assailant uses sex to inflict humiliation, to exert power and control, or to use the victim for their own sexual gratification without regard to the victim's consent. So similarly, in this bill, the disclosure of an unsolicited image causes harm and by its very nature is a form of sexual harassment. Experiencing any form of sexual harassment or sexual assault can be extremely traumatizing to a victim and can have long-lasting physical, emotional, and physiological effects. What we often see is that abusers use grooming tactics, including the disclosure of sexual images, as a means to draw in a victim, often a young person, into a sexual relationship. This often happens through very gradual and calculated interactions that are designed to gain the trust of the victim, and often in a relationship that is in secret. So when a perpetrator sends someone an unsolicited image, it's a deliberate act to upset them, to embarrass them, and to make them feel powerless. So such non-consensual interactions, regardless of someone's dating status or whether they even know each other, reflect a lack of consideration and respect for the victim's personal boundaries. Sending these kinds of images is no less severe than groping or harassing someone in public, and truthfully to victims, it's no less alarming or unsettling. So this bill moves New Hampshire in the right direction by prioritizing individual safety and well-being by requiring that the individual who receives the images freely consent to the receipt of those images. It also sends a strong message to Granite Staters of all ages about the importance of consent in all forms of interpersonal relationships. So the second reason we support the bill is that House Bill 1388 is consistent with existing New Hampshire law. New Hampshire already has a number of statutes, as the sponsor alluded to, that address various types of abuse and sexual exploitation that stem from exposing people either to sexual images or sexual conduct. In New Hampshire, sex-based crimes are usually at a minimum a misdemeanor. And it's really important with this bill that any new crime that impacts sex crimes fits in with the existing statutory structure, which is complex. Under current law, sending an unsolicited sexual image to someone who is under 16 is a felony. So it's very parallel to our current statutes to provide that if that image is sent to someone who is 16 or over, that it would be a misdemeanor. So in conclusion, this bill ensures that those individuals who are 16 or older who receive these unsolicited images that are so upsetting are protected, and this bill also is drafted in a way that's very consistent with our existing statutes. So we're in support, and I'm happy to take any questions.
Thank you very much for your testimony this afternoon. Are there any questions? Okay. Senator Khan.
Thank you, Madam Chair. So in the instance of a sending to a minor, 16 and under, I'm sorry, less than 16 years, that's a felony.
Thank you for the question, Senator. That's correct. Yes.
Here, it's a misdemeanor when it's somebody older than 16.
Yes, that's correct. Thank you.
And on a second offense, what is the crime? What is the charge?
The existing statute addresses that, and it would not raise it to a higher level offense for a second offense.
It would
not. It would remain as a misdemeanor.
It would remain as a misdemeanor?
Yes.
And on the third offense, becomes a felony?
The statute is silent on a second offense under this section where it's drafted, so it would continue to be a misdemeanor. And I'm also aware that there's a prosecutor here to testify who might be able to speak to that in greater detail. But the existing statute does not provide for an increase in the level of penalty for subsequent offenses.
Okay.
Are there any further questions from the committee? Seeing none, thank you very much for your
Thank you
testimony.
very much, and I'll leave my written testimony.
Thank you. The chair calls Stephen Andres. Good afternoon.
Good afternoon. My name is Stephen Andrus. I work for the Merrimack County Attorney's Office.
Okay.
I'm an assistant county attorney. I've been a prosecutor for a little over 20 years. I was in the Concord City Prosecutor's Office before Merrimack County. So I have a lot of experience in court as a prosecutor. I've read the proposed language, and I think it's a well-written statute, and I would agree with its passage. To answer Senator Khan's question, this would be put under a paragraph 1A. So you could do this, I don't want to say as many times as you wanted, but it would be a misdemeanor for each conviction going forward. And I'm very happy to answer any questions anyone has.
Okay, thank you for your testimony.
If I
Senator
could,
Khan has a question.
In the event that you're the last prosecutor that we have before us, that it's not progressive? Is there any flaw to this being a recurring misdemeanor offense and not something that becomes more progressively elevated?
I think that's really a policy decision for you guys to make. I certainly wouldn't have any difficulty with repeated offenses increasing in severity. I think if you do this once and you're convicted of it as a misdemeanor, you should have a pretty clear idea that you should not continue doing this. And if so, maybe a higher level offense would be appropriate.
Thank you.
Are there any further questions? Okay, seeing none, thank you very much for your testimony.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1388? Okay, seeing none, we'll go ahead and close the public hearing.
I would look forward to seeing her amendment. That's fine. You have a suggestion? Talk to them. No, I'm saying it's a good idea. That was a good idea on your part. That might be a good idea.
Thank you.
3 strikes and you're out, Jay. Sounds good.
Thought we were getting rid of the 3 strikes and you're out law.
What's that?
I thought we were getting rid of 3 strikes and you're out.
There you go. Yeah, 3 texts and you're out.
Okay. Okay. You ready? Okay. I'm going to open the public hearing on House Bill 1461 and recognize the prime sponsor, Representative Green. Is Representative Green here? Okay. Jen, I'll go ahead and I'll just do it from here, okay? Good afternoon. For the record, my name is Sharon Carson, and I'm here to introduce House Bill 1461. The prime sponsor, Representative Green, is not available, and this bill establishes penalties for littering on any right-of-way. Thank you very much, and we'll move on. The next person to speak is no one. There is no other person to speak. Is there anyone here who would like to speak to House Bill 1461? I know, Mr. Stock, you signed up, but not to speak. Would you like to speak?
Sir?
Okay.
I'll say a few words.
Please
We
come.
have something in the record on this.
Okay. Thank you very much, Mr. Stock.
All right. Well, good afternoon. For the record, my name is Jason Stock. I'm the Executive Director of the New Hampshire Timberland Owners Association. And I'm here in support of this legislation. As landowners, and particularly landowners who have roads and right-of-ways that crisscross their property or run adjacent to them, litter and trash is a frequent and common occurrence. And we just felt, when our policy committee reviewed this, we felt that this policy was an appropriate way to try and kind of raise awareness and raise the stakes on this perpetual problem. I have landowners who, it's almost like a season. You have summer, fall, winter mud season, and then you have trash cleanup season, where they'll go out and if it's an old log landing or a piece of a road that's discontinued, at the end of it, it just seems to collect trash and litter. And as they've told me, the interesting thing is that all the washing machines that they leave in televisions, none of them work. So, you know, it's an expense. And all joking aside, there are members of our association that will pay thousands of dollars a year picking up and disposing of other people's trash and litter on their property. And so for that reason, we are testifying in support of this. And I'd be happy to try and answer any questions, and I do appreciate the opportunity to speak.
Thank you very much for your testimony, Mr. Stock. Are there any questions from the committee? Okay, Mr. Stock, I remember, I don't know if you were involved, but a few years ago in this committee, we had a group of landowners that came in. People were, they had opened their land up, current use, they had opened up their trails, and people were coming in and just not only destroying the trails, but they were also dumping a lot of garbage, furniture, things of that nature. And I believe we put penalties in place, enhanced penalties for that.
Yes.
So that they were going to be able to find out, you know, because a lot of them will put up trail cams. And I remember seeing tons of pictures of the damage and the garbage. Is this bill going to conflict with what we've already done?
I don't believe it will. I mean, this bill, as we read it, is more specific to rights-of-way, whereas if I drive off the road or off that Class 6 road and drive onto your property and dump debris, anything on that, that's off of the right-of-way. So this one is more on that right-of-way. So if you think of kind of the classic two stone walls and the dirt road, many times it's that wall-to-wall is the legal right-of-way. And so although it's, you know, technically the right-of-way, it is, in many cases, you know, it is, and obviously it's visual, it's an eyesore if there's litter, but many times on Class 5 and 6 roads in particular, the landowner still owns the soil underneath that right-of-way. So again, we don't believe this would conflict with that because it's right-of-way, it's a nuanced right-of-way versus property.
Would this also apply to utility right-of-ways?
I didn't think of that. I would have to take a closer look. That didn't occur to us. When we saw right-of-way, we immediately think roads, trails. We did not contemplate that. That's a great question.
Okay, I was
All
just
right.
curious about that. Okay, are there any questions? Senator Khan has a question. Do you have a question?
Just, what is the current fine? Is there any
I am.
specified?
I don't have it here. I know on our road it's posted, as I drive by it every night on our Class 5 road, and it's an odd number. It was like $233.85, but that's on Perkins Road in Tilton, New Hampshire. I'd have to pull the statute up and take a closer look. But what we liked about this was the kind of multiple offenses. You know, if you have someone that kind of makes a habit of dumping their tires and old trashed furniture, and you have them on trail cameras, and they're dumping it on that Class 6 road, that was the one piece that really appealed to us, is kind of the raising the stakes aspect of it.
Because what I'm unable to find is in the reference to the statute that we're amending here. I don't see a...
And again, that might explain the oddball, because when anyone comes and visits, they always comment on this road signage on our road that if I'm caught littering, I need to have my pennies and nickels with me to help pay the fine.
Senator, I think in the bill on line 1, it does say amend RSA 265:102, comma, Roman 4. Maybe that's what you're looking for. Okay. Okay.
reference to it now.
Okay, thank you. Are there any further questions? Seeing none, thank you very much,
Thank you.
Mr. Stock. Are there any other members of the public that would like to speak to House Bill 1461? Yes, you are?
Thank you, Madam Chair. For the record, my name is Caleb Dobbins. I'm the State Maintenance Engineer for the New Hampshire Department of Transportation. Initially, we weren't going to testify as we have no position on this bill, but I thought there might be some information that we could provide that would be of benefit to the committee relative to it. I believe Senator Khan's question might have been, what's the current fine for this? I seem to have found in the fiscal note for this, it seems to say $62 is the current for first offense and $124 for second offense. This appears to go from up to $300 and $500. And relative to the finances, that's kind of where I wanted to settle on. So the Department of Transportation oversees about 9,200 lane miles of roadway in the state of New Hampshire. We don't have a specific code that we charge just litter removal to, but we do have one that's considered litter removal and debris removal. So debris might be, you know, something that flies off of a truck like a tire or something, or for that matter, even like a dead animal. But the vast amount of the cost for that operation is for litter removal. It's for the removal of litter prior to mowing so that we don't go from one piece of trash to 100 pieces of trash when we hit it with the mower. And for all told, I looked at our records, and just for the labor, not for the actual disposal of the litter, but we spend almost $1 million a year on litter and debris removal. And that encompasses about 30,000 man-hours throughout the state, and that doesn't take into account the numerous miles that we have that are adopted by volunteer groups. We will go out and we will pick up the bags when they're all done, and we will dispose of the trash. And again, the funds that I just explained to you do not encompass that work. So I'd be fairly comfortable to say, you know, somewhere between around $750,000 to $1 million a year the New Hampshire Department of Transportation spends in terms of picking up litter along the roadsides.
Okay, thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Last call here. Are there any other members of the public who would like to speak to House Bill 1461? Okay, seeing none, we close the public hearing. Thank you. Okay, are you ready, Jen? I'm going to open the public hearing on House Bill 1475 and recognize the prime sponsor, Representative Trottier. Okay, seeing that Representative Trottier is not available, the chair will call Representative O'Hara.
Thank you, Madam Chair and members of the committee. For the record, I'm Representative Travis O'Hara, representing Belknap 9, Belmont, and Laconia. This is a housekeeping bill that Representative Trottier brought to our attention, that we were giving the Liquor Commission the powers of the sheriff, which is a constitutionally elected position. So we were originally going to change it to state police, which then limits actually their jurisdiction in town, which I didn't know. So we just changed it to statewide jurisdiction. During the House Committee, the Commission spoke in support of the bill, which I believe they're here in support today still. But just to address one of the concerns on the back for expenditures, they were worried about more litigation for enforcements, because it sounded like we were trying to limit the powers. But if you look on line 4 through 5, it still says with reference to enforcement of all laws, either in cooperation with or independently of. So they still have enforcement of all laws. And with that, I would be happy to take any questions.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Okay, seeing none, thank you. The chair will call Aidan Moore, and I believe you have Mr. Culver with you as well. Would you both please come forward? Good afternoon, gentlemen. When you speak, please introduce yourselves so we'll have accuracy for the records.
Thank you, Madam Chair. My name is Aidan Moore. I am the legal coordinator with the State Liquor Commission.
My name is Matthew Culver. I'm a lieutenant with the Division of Enforcement and Licensing in the Hampshire Liquor Commission.
Madam Chair, we're here to support the bill as amended. I think Representative Trottier had some concerns, as you heard, about the language that appears in 17959 describing the enforcement powers as that of a sheriff. And we believe that this change in the law, striking that provision that says all the powers of the sheriff in any county and replacing with statewide jurisdiction, will satisfy and keep the authority that the commission has now in place. I should point out that the methodology on the document that you have was written when the bill was first introduced. So the language here that suggests that if the bill were to become law, there'd be increased litigation, et cetera, that is no longer accurate. So it does still appear here, but it would not have any applicability moving forward. So we support the bill as amended, and we'll be happy to take any questions if you'd like.
Thank you very much for your testimony. Mr. Culver, do you have anything you'd like to add?
Thank you, Madam Chair. I'm here just to answer the questions if there's anything from the committee members.
Okay, thank you. Are there any questions from the committee? Okay, seeing none, thank you very much for your testimony.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1475? Okay, seeing none, we'll close the public hearing. And
You're a marathon runner. Found it, steady pace.
yeah, well, you just, yeah, we're right on time. It's 2 o'clock. I know. Yep, I have 2 o'clock. Okay. Okay, Representative Roy is not here. Okay. I will do the same thing. I just want to get the bill. Well, it doesn't mean that that's their opinion. Okay. Are you all set, Jenny? Okay. We're going to open the public hearing on House Bill 1505. And is Representative Roy here? Okay, seeing that he is not, I will go ahead, Jenny, and introduce the bill. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon House Bill 1505, which seeks to establish concurrent jurisdiction in juvenile matters pertaining to the lands located within the boundaries of the former Pease Air Force Base and provides for coordination with the Military Family Advocacy Program. Okay, we're going to go ahead and call Mr. Perry. Good afternoon, Mr. Perry.
Good afternoon, Madam Chair. For the record, Warren Perry, Deputy Adjutant General, New Hampshire Department of Military Affairs and Veteran Services. I hadn't intended on testifying and just supporting the bill, but I'll be happy to answer any questions that you might have. I think most importantly, I would call your attention to the written correspondence that came from Mr. Chris Arnold from the Department of Defense. And if you haven't seen that, that summarizes the department's support of this bill as well. It will enable sharing of information and protect children better. We already have these agreements, primarily with the folks in Massachusetts that work these kinds of things, but this just codifies it in law and makes it a little bit simpler to share information. My understanding is it passed unanimously in the House, and it's a good bill. So I'll be happy to answer any questions.
Thank you very much for your testimony. Senator Whitley has a question.
Thank you, Madam Chair. Thank you for taking my question. So, it sounds like, you know, that by agreement or by memo, you can sort of get what you need right now. So what are the barriers, existing barriers, making this necessary?
Yeah, so I'm not uniquely qualified to answer that question, Senator. I apologize. You know, it would be better answered by Mr. Arnold or by the folks at DCYF. I just know that this just makes it easier. I mean, that's my understanding of the bill. I'm sorry I can't answer your question. I apologize.
Are there any further questions? Seeing none, thank you very much, Mr. Perry.
Thank you, Senator.
The chair will call Kevin Grady.
Thank you, Madam Chair. Ladies and gentlemen of the committee, for the record, my name is Kevin Grady. I am a 25-year veteran of our Air Force and a 22-year resident of the town of Hooksett, New Hampshire. Today I'm here representing the State Veterans Advisory Committee. And for those of you unfamiliar with what we do, we're chartered by State RSA 115:A-8 to speak for the veteran community. We take a look at bills that come before the Senate and the House that have military impact, and we discuss them, and then we make a position, and then I come and tell you what that position is. We do support this bill for many of the reasons that Mr. Perry just told you. It makes life easier in terms of getting the information that we need between the agencies. A lot of what we're talking about, changing these, kind of cleaning up the language in these bills, a lot of this is happening already. But we're just kind of codify the fact that that this is the way we want to do it going forward. And especially where there are programs that start at a federal level and then they work their way down to our level. And sometimes when those programs have money attached to them, it is much better if our procedures are the same as their procedures, if there's not a lot of difference between that. And as military folks, standardization is, we're big on standardization. We're big on using checklists. As a pilot, I can tell you we have a checklist because, you know, that all the steps need to be done in the right order and they all need to be accomplished. So we do support this legislation. Again, Mr. Arnold's stuff on this is very clear on exactly what the nuts and bolts are of it. But just from what he briefed to us, we do support the legislation. So subject to your questions, that's all I wanted to tell you this afternoon.
Okay, thank you very much for your testimony, Mr. Grady. Are there any questions from the committee? Okay. Seeing none, thank you very much.
Thank you, Senator.
Are there any other member of the public that would like to speak to House Bill 1505? Okay, seeing none, we'll close the public hearing. We are done for the day. I know, if I did.